And for me to introduce our moderator, I would like to tell you that Mr. Oliver V. Yangshin, the Master Builders Association Malaysia President, and also the Vice Chairman of IFAUCA Conditions of Contract Committee and Ambassador of IFAUCA to FIDIC. He is also one of the organizers. In fact, he is the main organizer of this event. He has been involved in the construction industry for over 35 years with numerous iconic projects, both local and international. With his educational background in economics, he worked his way up from being a quantity surveyor to earn his seat at the C-suite table as Business Development Director. As the chairman of MBAM Contracts and Practices Committee since 2012, he has organized many educational events for the benefit of contractors and subcontractors. He is an active representative of the voice of contractors in industry initiatives, such as the promulgation of CIPAA, or the Construction Industry Payment Adjudication Act. He is also a panel mediator under Construction Industry Development Board, CIDB of Malaysia, and Asian International Arbitration Center. Under his leadership, MBAM Mediation Services was set up and successfully launched in June of 2019. Let us all welcome our moderator for this forum, Mr. Oliver Wee.
Thank you, Barry, and good morning, everyone. Well, we all know dispute is something no one allows for at every tender stage. However, it seems to be a very normal element in most of our projects nowadays. Well, the objective of organizing this event today is mainly due to the dispute in our construction industry increased tremendously in many countries like Malaysia, and I'm sure among the IFAUCA countries as well. And as usual, there are numerous alternative dispute resolution available. However, especially in Malaysia, in recent years, adjudication is the most commonly adopted claims adopted by the claimant on payment dispute. And however, there are still more than thousands of cases stuck at all levels of courts today. Now, I hope today's sharing would help contractors to get ready and understand what is dispute, how to avoid dispute, how to manage dispute, and if you have no choice, choose the right path and right way of settlement, rather than just go legal without seriously consider the consequences. Now, it looks like we have not much time left. We probably would, let me see, to answer the question thrown by the floor. Okay, this from Mr. Chris Tan. It says it is compulsory to get settlement agreement registered. I prefer he is referring to mediation. It says certified accredited mediator stamp sufficient. If it's require registration, then which body or probably which body to be registered? I think it's very subject to which jurisdiction you come from. My fellow panelists, what will be your advice to this gentleman or lady?
Since this is a mediation question, I will answer it. I suppose the question is asking, all right, in the context of Singapore. In Singapore, we have the Singapore Mediation Act 2017. In this particular act, all right, a mediated settlement agreement can be registered or apply to the court to be registered or recorded as an order of court. But under the Singapore Mediation Act, in order for the mediated settlement agreement qualify to be applied to court, it must be mediated by a certified mediator, the term certified mediator. And in Singapore, the term certified mediator is basically the mediator from CIMI. As I mentioned to you, CME, there are 4 levels: level 1, level 2, level 3. They are known as accredited mediator. They are not certified mediator. CME level 4 mediator is known as certified mediator, which I am. I'm a certified CME level 4 mediator. It's only a mediated settlement agreement mediated by a certified mediator is eligible to be applied to Singapore court, right, for it to be recorded as an order of court. Alternatively, right, there are 4 designated mediation service provider that is under the Act, right, can be recorded as a court order, right? They are SMC, SIMC, CADIM, and WIPO, WIPO. So these are the 4, right? But
Yeah,
I can
thank you,
add on,
thank you.
I can add on to one more, because in the Singapore Convention Act, right, the International Settlement Agreement, similarly, right, if it's having such a settlement agreement, as long as the requirements stipulated under the Act, right, whereby one of them is the mediator must sign on the agreement, then it is also eligible, right, to be recorded as an order of court.
Okay, thank you, thank you. I think it's clear enough. The next question is actually posed by Mr. Jaffa. It is an interesting one. Its question, it reads, there have been several cases of construction delay dispute with the effect of delays in payment. Initially, it was a civil case and then turned into a criminal case. And his questions are, is it normal in law construction as civil cases become a criminal case? Is it possible? If yes, how to avoid and solve it? I hope he is not a party. And, and from where to start? And how did FIDIC regulate? I mean, FIDIC is not here. So probably we can discuss is how can a civil case turn into a criminal case? Perhaps a 2 lawyer can advise a bit.
Let me have a go at that first. It is not common. So that's the short answer for civil case to end up being criminal unless there are criminal elements. Okay. So I've come across 1 or 2 civil construction disputes which have ended up being criminal, not because there are criminal elements, but because it involves breaches of statutory regulations. So for example, DOSH, we've got an Act, Department of Safety and Health. The Act requires certain things to be done. Failure to comply amounts to a statutory wrong. So, and if it happens on site, for example, when you expose your employees to dangerous site conditions, you could be prosecuted under the DOSH Act. So that's one instance where it can become criminal, but certainly non-payment. I've not come across non-payment issue becoming criminal, although most contractors were treated as being criminal. I don't think we crossed that line.
Could it be during the evidence or exhibit where some other compliance exposed or surface, like corruption and things like that?
I think that's a possibility. I've not come across a situation like that.
What say you, King?
Well, I think most of the times, what a contractor alleged when they are not being paid is that they say the employer is cheating them, and cheating is of course a crime, right? But what constitutes cheating in your mind and what constitutes cheating as a crime are 2 very different types of issues. But instead of looking at I would concur with Jun Liang that it's not common for a civil case to become a criminal case. But then there are also situations where you could potentially go behind the corporate entity of the company to go after the directors, where you think that the company has been used as a sham or has been used as a cover to, in layman's language, cheat, right? To commit fraud. And so then you can go after the directors. Now, I think I have seen more cases of that, and I've handled more cases of that, where you try and go after the directors personally for issues like non-payment, as opposed to going to the police. Most of the time, the police say this is a civil case, nothing to do with them.
Yeah. All right. Well, I think the next question is from Pachi, probably is a contractor association from India. a very hot topic now is how to assess incidental and unforeseen risks like COVID-19, Russian-Ukraine war, natural disaster like flood, earthquake, which affect the construction costs, and contractor got losses, and how can it be compensated? A lot of time we only think about contractors, like we never thought about the clients. Like it's actually the same effect. If it's a natural events happen, well, perhaps we can give some thoughts on this. Jun Liang, what is your opinion on all this natural disaster?
In terms of, sorry, Oliver, I'm trying to understand the question, the impact of natural disasters on a construction.
Yeah.
All right.
So the contractor got damages or losses due to this natural disaster, and how can it be compensated?
Yeah, a lot of these, let's leave aside the insurance factor.
Yeah.
Whether you get compensated as a contractor for natural disasters, you are looking at compensation from the employer, obviously, because this is contractual, right? So the answer always is that you look at the terms of your contract. Most contracts treat these as neutral events, so the loss will lie where it falls. All right. There is, of course, an implied duty on the part of all contracting parties to mitigate loss, mitigate damage. So if you can pin it down to an act of negligence by the other contracting party, you may have a small window to make a claim. Otherwise, most contracts render these as being neutral. The loss will have to lie where it falls. That also extends to time and cost issues.
Yeah, I hope this can answer our question to our participant. Now, just a very common question that I would like to ask Keng Ho in terms of contract administration. You see, many a time we are having dispute over VO, EOT, loss and expense with the client. But what happens if we keep writing and notify them and there's no response, especially on EOT application? Many a time contractors are caught in the situation that by the end of the day, where the contract administrator is only offering you time without cost, and you are like arm twisted to accept such situation. And what can a proper contract administering works to be done to overcome this situation?
Well, the problem is that the question within that question is the idea that the contract administrator is already not assessing things fairly, right? So you're applying, the contract administrator is actually just ignoring you or not assessing your claims, even within the terms of the contract. And if that happens, there's really very little the contractor can do except to push the matter into disputes. So depending on the nature of the claim, then you could potentially do adjudication situation. Malaysia's adjudication is only for payments, but other jurisdictions allow adjudication even for time, for instance, right? And depending on the nature of the claim, whether the loss and expense is something you can claim right now, or you've got to wait until the end of the contracts to claim for it through the arbitration process. So again, the problem is that, but the good thing for the contractor is that you need to do your part. And as long as you do your part, then you're safeguarding your rights. At the end of the day, when the dispute eventually comes to, like Jun Liang was saying, it falls on the head of the consultant or the contract administrator who has failed to administer it properly. And hopefully he is, on the one hand, he could be failing to administer properly under instructions, in which case he may be safe if he's properly documented, or it may even fall on his own head for failing to administer it properly, causing a loss to employer for which the employer can claim against him. But really, we can't really control very much, right? We can't force people to act fairly. We can't force people to act reasonably. We can only do our part.
That's why we always say contractor is always at the worst position of the whole food chain. You will be dragged, but your money is out. You're facing cash flow problem, and your subcon, your supplier is coming after you. Even though you have a very good case to go into arbitration or litigation, but you may not last that long. Well, I think there's very common issues where all contractors face in all over the world. Well, I think one thing good, just for sharing to other countries member, I think Malaysia had our Adjudication Act implemented since 2014, and it really helps. It really helps out the contractor cash flow to a certain extent. And in the past 7 years, I believe, we have averaged about 500 to 600 adjudication cases a year. So I think it's working, and I also hope that our other country members should push for your own Adjudication Act, and it really help out on the payment dispute. Now, the other one more thing I would like to check with Keng Ho is, you have in your presentation, you have actually demonstrate the risk and reward balance, where the risk is on the contractor high and the benefit on the client is better and so on. But would you think the other mode of construction business model would be better, such as like design and build or a turnkey project? You know, would it be reducing more dispute by using that form of contract? Say if it's a turnkey or design and build, would the dispute, would you see the dispute will be reduced by using those mode?
The design and build contracts have its fair share of disputes as well, because in the design and build contract, in addition to the normal payment terms, there is also the obligation of design, right? What you remove probably from the what you remove would be the design stage faults of the employer. So the dispute on the design stage fault gets reduced because design is now passed to the contractor. So the contractor and the employer can't really argue over the design stage fault. But the contract construction stage, the disputes remain, payment issues will still be there.
Well, payment probably yes, but a lot of variation could have been taken care of by the design stage. For example, if the unforeseen elements that have not overlooked, oversighted area where designs are been forgotten at the design stage, probably those areas can be reduced. Probably.
On the other hand, the obligation of design then falls on the contractor, which also means liability of design also falls on contractor.
Correct. So there will be lesser dispute raised by the contractor in a way.
So hopefully the price
it will be definitely higher.
The price justifies additional obligations.
Yeah. Now I think Mr. Lee, I think when I Google your Singapore Mediation Center, it very impressive achievement through the past on the number of matters that referred to the mediation center and the number of method settled. So I wonder whether since your Singapore Convention signed up since 2019, what are the positive impacts to your social economic sector, such as are the dispute reduced by many people going to mediation, and or is your foreign investment increased because of the foreigner will view it, your mediation can be enforced even cross-border agreement?
Well, this is a very high-profile question. Okay, I only can answer in part, all right, whether the FDI has increased the past few years from foreign companies to Singapore. I do not have data for that. But with the recent completion of the Singapore Convention, right, CITRA have actually carried out a survey. Mainly, their survey group are with the international mediation user. And what they reflect is that they find that it's very important for this international mediation user. They would like to look at the mediator's experience or the mediator code of conduct. And over the period of the convention, I think with the so overwhelming foreigners and the locals mediators as participate in so many of the events, what we understand that mediation is really taking part in Singapore, both domestically and internationally. I won't have a figure to tell you whether is there an increase or reduce. But what I can safely say, all right, they are regularly having mediation in Singapore in all aspects. Frankly speaking, today is only the 5th of September. I already did one mediation, 1st of September. I have a mediation tomorrow. I got another mediation on Friday. So you can imagine there are many big and small disputes, right, coming to Singapore, right? And we believe that if the strength of Singapore, right, is being the center for mediation, and Singapore was SMC, SIMC, SCMC, and many others mediation service provider, right? Whether it's locally or foreign, and particularly with the advent of online mediation. So even foreign disputants can find the suitability of Singapore mediators and Singapore as the right venue to have their mediation. Coupled with our CIMI, right, is particularly trying to train and make sure that the Singapore mediator, right, attain a certain high standard. So basically, mediation is the way to go, right, to resolve a person dispute, particularly if the disputants are able to identify conflicts, initial dispute or serial dispute, and have mediation as fast as possible to avoid having to go into adjudication, arbitration, or litigation. But obviously, all right, if the party really want a judgment, all right, then obviously they will need a judgment or they will need a determination by adjudication. But if not, if the parties merely want resolution, all right, mediation is the best avenue, and Singapore is also a good place. Similarly, Malaysia and any other country, right, in IFOCA will be suitable to have mediation as well.
Yeah, thank you, thank you. I acknowledge that. I remember you said even between boyfriend and a girlfriend also can mediate.
I say that, I mean, the triangular boyfriend-girlfriend relationship, and the tissue box is flying around in the mediation room.
Well, I think all industry and all countries, I think we acknowledge the benefit of advantage of mediation. The only thing is how can we legalize it or validate it. So I think that one we also working on certain form of contracts that we are trying to putting in. Mediation is something that we should go through before we get into arbitration. And we also include early warning system and also dispute avoidance. Keng Ho was one of the committee member drafting the new form or amended the new form. Hopefully that will come, can be launched probably early next year, I think. That will be a model for the rest to have a look. Well, thank you very much, gentlemen. I think our time is up. It's 12. President, do you have something to say to wrap up the whole session?
Thank you very much, Mr. Oliver, and all the panelists. I have been listening throughout, and it's been very impressive and very knowledgeable. I think, as I said earlier during the beginning, it's a new start for us, and the initiative taken by Mr. Oliver, and your team is really laudable, and I applaud for all the efforts that you have put in to make this a successful webinar. I hope this benefits the IFOPCA community, and as I have been communicating with Mr. Oliver, regarding the role that IFOPCA could play in future in helping reduce and avoiding construction disputes. I think from today's deliberations, we can come to a conclusion that we have, very good experts, professionals who could be playing advisory roles to us. And if our members have, challenges in their countries and in their various businesses, companies, I think IFOPCA could play an advisory role and direct our members to the right arbitration or dispute avoidance situation. So I think it is also high time that under your leadership, Mr. Oliver, that we try to establish the relationships with the arbitration centers around the Asia Pacific region, so that contractually I think most of us are now putting a clause of arbitration in countries like Singapore, Hong Kong, and I think we could give more opportunities and more doors open for our members to be, having an easier path to resolve their problems. I think after COVID and after what is happening in the world right now, the challenges are a lot more than what was before. And because the governments are also suffering, the clients are also suffering. So I think the only path we have is to avoid major, conflicts between the client and the contractor. That would save money. That is the conclusion we are coming to. All of us are agreeing today that avoiding dispute is the best way to save money and to save our businesses. Once again, thank you very much for all your efforts, and to all the panelists, thank you so much for giving your valuable time. And we will issue a note of appreciation, like a certificate from IFOPCA for your contribution today. And Barry and Melody, please prepare those appreciation certificates,
Mr. President.
and we will present it to you very soon. Thank you so much for your time.
Collect your certificate in Maldives.
Yes, please come, and I'm more than willing to welcome you. I think it would be interesting to have a small session like this, during the Maldivian
We should.
convention, or you can plan something, a 1 hour session or something like that.
Yeah,
Maybe
yeah,
in between we try to find out something like that, right? Okay.
All right.
They're already complaining I have too much programs,
Dispute avoidance.
Thank you so much.
All right.
Before we conclude the webinar, can we take one picture, please? Just one. Okay. Smile. 1, 2, 3. Smile. Thank you, Sir Barry.
All right. Thank you. Thank you, everyone. Thank you so much.
We wind up. We would like to thank everyone who spent their time with us. To the speakers who gave all their expertise in an effort in sharing their knowledge to us, to our compassionate IFAUCA president for your leadership, and to Mr. Oliver Wee for your time and effort in organizing this first online forum of IFAUCA. And lastly, to all IFAUCA members for their support. We hope to see you again till our next event, hopefully not only in Maldives, but also in Malaysia this coming October. Thank you all, and be safe. Bye-bye.
Bye. Thank you so much. Bye-bye.
Thank you, everyone. Thank you.
Bye.
Be safe.